Tell me how you want your lower third to read. Do you want just, how would you like?
I'd say Robert Dunham, Director, Death Penalty Policy Project.
Okay, cool. All right. So let's talk a little bit about you. Give us a brief about who you are, your experience, that type of thing for everyone.
Well, I never thought I was going to be a death penalty lawyer. When I went to law school, I had been working for a state representative for 4.5 years, and I became his campaign manager. I did press secretarial type work, constituent service, and he finally said to me, "Rob, you're too smart to be earning $12,000 a year." And so he suggested that I apply to law schools, which I did. And when I was at Georgetown for law school, I was on the Law Journal, and the Law Journal does a project every year called the Criminal Procedure Project. And it looks at the decisions by all the federal circuit courts in a wide range of issues. So I got assigned the death penalty. And the year that I was there, that I was writing the section on the death penalty, there were a number of major U.S. Supreme Court decisions that pretty much changed the landscape of death penalty law. And so I essentially became a legal expert in the death penalty by virtue of doing that work. And I not only had to do a summary of what the United States Supreme Court had done, but how all of the circuit courts, federal circuit courts, were applying the law. So I got to know the law across the board in all the federal circuits in the states that had the death penalty. I still didn't think I was going to be a death penalty lawyer. And my ex-boss became Speaker of the Pennsylvania House of Representatives, and he asked me if I wanted to be chief counsel for the House of Representatives. And that sounded like a great idea, but I couldn't afford it because my student loans, and Georgetown's a good school, but it costs a lot. So I ended up going to a private firm in Philadelphia, one of the major downtown law firms, and I got a pro bono death penalty case. And as I'm reading the transcripts, I'm looking down and it says, "Court adjourned for Tuesday for Election Day." And the lawyer in the case was somebody that I had known and respected as a politician in Philadelphia. And I realized, because I'd been a Democratic committee person, that the Tuesday on this transcript was the weekend after he had been at my grandparents' house for a campaign event when he was running for city council. And instead of preparing for his death penalty case, he was out campaigning. And that kind of shocked me, because this was somebody I had regarded as being a politician who worked in the public interest. And I thought, this is bad. And I spent a lot of time on the case. Ultimately, we won a new penalty phase for the client, and then he was found to be intellectually disabled, so he wasn't subject to the death penalty on a retrial. But after 4 years doing that case, a position came open. The new Pennsylvania Capital Case Resource Center was opening. And after the third person at my law firm said, "Hey, we saw your next job in the paper," I thought, this is the serious injustice in this case, and this case can't be different from the other cases that are going on. Let me see what happens. I have nothing to lose, and I was offered the job as executive director, and I've been either representing people on death row or engaged in policy analysis of capital punishment ever since, and that was 1994. So, as I said, I didn't think anything about being a death penalty lawyer. I thought I was going to be a First Amendment lawyer. I was going to do something in the public interest. But when you're talking about public interest and social justice, it's a big river, and there are lots of streams that flow into it. And if you are committed to doing something in the public good and something good attracts you, then you stay with it, it'll suck you in. And the death penalty is a fascinating area. It's an emotionally wrought area. And if you're interested in correcting injustice, it's the place to be.
You just gave a promo for, you know. One second. Are you hearing the clicks of the camera?
No, I don't.
Okay, good.
I'm good, yeah.
Okay, good. Thanks. So let's talk about, let's jump to Atkins for a second. So 20 plus years removed from the Supreme Court decision in Atkins versus Virginia. And courts are still, sentencing people with intellectual disability to death, and ultimately being executed. Can you give us in your opinion, where are we now with the death penalty and intellectual disability? Where are we now from your perspective?
The history of the modern death penalty in the United States has been moving away from using it. And historically, what we've been seeing is a chipping away one type of issue at a time. And one of the things the Supreme Court had done was to provide protection against using the death penalty against certain vulnerable groups. There had been numerous people with intellectual disability who had been sentenced to death. And the human rights movement around the world recognized that it's inappropriate to be subjecting people with intellectual disabilities to the ultimate punishment. The United States was far behind the rest of the world, but one by one, states began passing laws saying that we're not going to use the death penalty against people who, it was called mental retardation at that time, people who are mentally retarded. So the United States Supreme Court in 1989 was asked to declare the death penalty unconstitutional for defendants who are mentally retarded, and they said no. They said that the death penalty is constitutional, but courts have to and juries have to consider a defendant's intellectual disability as a mitigating circumstance, as a strong reason to spare their life. From that time forward, more states said, no, we're not going to allow the death penalty for intellectual disability. More people became aware of intellectual disability as a disorder, and the United States Supreme Court changed its mind. And it ruled in Atkins that you can't use the death penalty against individuals with intellectual disability. Now, the problem is, what's a person with intellectual disability? The Supreme Court has said you can't execute somebody who was under age 18 at the time of an offense. Well, that's pretty easy to figure out. So if you're 17 and 355 days, you're not eligible for the death penalty, but on your 18th birthday, you are. It's not so easy in trying to determine whether somebody has an intellectual disability. What results from that is that states that didn't want to exempt individuals who are intellectually disabled from the death penalty, they were able to define intellectual disability in a way that still allowed individuals who had mild intellectual disability, sort of like a mild hurricane, that left them at risk. And states like Georgia said that defendants have to prove that they are intellectually disabled beyond a reasonable doubt. That's an unmeetable standard. And no jury in Georgia has ever found a person who was convicted as the killer to be intellectually disabled. And Georgia has executed people even though every clinician who examined them agreed that under the medical definition of intellectual disability, they qualified. But that just means that to a reasonable degree of medical certainty. That's not beyond a reasonable doubt. And that's the judgment of a medical professional. That's not the judgment of a jury that's been asked whether it is willing to cast the first stone. And only those who say they're willing to cast the first stone are allowed to participate in the determination as to whether the person has intellectual disability. So that was one of the barriers that states erected. Other states that didn't want to exempt individuals with intellectual disability came up with different definitions. So Florida said you have to have an IQ test below 70. And that was a hard cutoff. And if you had an IQ test above that, we wouldn't even look at anything else. That's not how intellectual disability works. And so a whole range of individuals who probably had intellectual disability but had an IQ test score that was above that threshold, they had their claims denied. And the appellate courts denied their claims. And the United States Supreme Court declined to look at the case, and they were executed. And then in states like Texas, the Texas courts decided that the medical definition of intellectual disability, we're not going to use that. We're going to come up with our own standard, and they invented something that's called the Brasenio factors. And it's called the Brasenio factors because of the name of the defendant in that case. And so Mr. Brasenio was judged not to be intellectually disabled because there were a whole series of questions that the Texas Court of Criminal Appeals wanted the courts to look at that had absolutely nothing to do with whether somebody was intellectually disabled or not. Were they regarded by others as being intellectually disabled? Were they able to hide their involvement in the offense? Well, people who are intellectually disabled aren't vegetables. People who are intellectually disabled can have very significant skills, but there are stereotypes. And with these Texas stereotypes, we ended up with well over a dozen individuals being found not to be intellectually disabled under the Brasenio factors, and then some of them were executed. So states that want to carry out these executions have found ways of making it difficult for individuals who are intellectually disabled to prove that they're intellectually disabled. And for the most part, the United States Supreme Court, especially after the death of Justice Kennedy, who wrote the opinions on, I'm sorry. And so especially after, it wasn't the death of Justice Kennedy, and so, yeah. And the United States Supreme Court is not intervening. And so especially after the retirement of Justice Kennedy and the death of Justice Ginsburg, who were key votes in all of the Supreme Court decisions that narrowed the use of the death penalty, we see that the court now is refusing to intervene. It's allowing states to present all sorts of obstacles to proof of intellectual disability. And we've had in the range of 30 people who likely had intellectual disability being executed even after the United States Supreme Court says you can't.
So for the layperson, just looking at this, why shouldn't we execute these individuals? Well, I mean, why is it important that we stop these executions from your perspective?
Well, I'm going to back away from my perspective.
Okay.
When we talk about executing people with intellectual disabilities, you're talking about the most vulnerable of defendants. And when Atkins was being litigated, the medical community, the mental health community, the disabilities community, all were trying to make clear that people with intellectual disabilities, while they are capable of doing many things, have significant disadvantages. And they have significant disadvantages in terms of understanding. You have to have significantly sub-average intellectual functioning, and you have to have significant deficits in your ability to function in day-to-day life. So subjecting the most vulnerable people to the harshest punishment and the most complicated legal proceedings is offensive to a lot of people, and it's offensive to most of the world. The United States Supreme Court, in a doctrine called the Evolving Standards of Decency, said that it offended the evolving standards of decency in the United States to subject these most vulnerable people to capital punishment. Now, that's not to say that if you're intellectually disabled and you commit a murder, you go free. In the United States, in every state that has the death penalty, the alternative punishment is life without possibility of parole. So if you have the most vulnerable people, and you have people who are least likely, least able to assist their counsel, least able to understand the court proceedings, and are most likely to be misunderstood by the jury, if you're going to make a mistake, if you're going to err, should you err on this person dies, or should you err on the side of this person's going to get the second most severe punishment known to any democracy in the civilized world? When you look at it that way, why should we be trying to take the lives of intellectually disabled people? It provides no increased measure of public safety, and it demeans our society.
I'm going to skip to a question I was going to save for later, but I think it's appropriate now. When you're talking about the public safety, it serves no use for public safety. We kind of talk about, this whole idea of, well, it's more cost effective. People, I was in a Uber, and I was talking to the Uber driver about the film, and he said, well, hey, why shouldn't we just execute these people? Because, they committed a crime, heinous crime, and it's probably cheaper for the state, and that's not true. But what are your thoughts on that? When people say, hey, it's more cost effective for the state, there's evidence out there that it's actually not.
That's right.
So,
well, in fact, every time that there's been a study, in every state, in every jurisdiction, federal, state, county, everywhere there's been a study, it's been shown that having the death penalty costs significantly more than a system that doesn't have the death penalty. Now, for a layperson, it's like, what? How do you get to that? And that's because the cost of capital punishment isn't the cost of a syringe and some chemicals. It is the cost of the entire proceedings. And that means pretrial, trial, appeal. It means cases that get overturned. It means cases in which the death penalty is not imposed. And when we look at it, there have been close to 10,000 death sentences imposed in the United States since the death penalty came back in 1972. The single most likely outcome of one of those death sentences is that the conviction or sentence gets overturned and does not get reimposed. And that means the most likely outcome of a capital trial is that all the resources that went into it were wasted. That's only the cases in which the death penalty was imposed. And when you look at all the cases in which the death penalty was sought and not imposed, in most of those, you'd had a much quicker and much more final outcome much sooner. When you have a death penalty case, the pretrial proceedings take longer. What does that mean? It means the county picks up more expenses for pretrial detention. It means there are more security costs. It means that because there is more you've got to prove in a capital case is not your average trial. A capital trial is the trial for guilt or innocence that we're all familiar with. And then it's a separate trial if the defendant is convicted of capital murder. It's a separate trial for life or death. That separate trial has implications for the first trial. And what it means is the defense lawyers have to prepare a case for life at the same time that they're trying to defend on guilt or innocence. That means they have to investigate the entire life history of their defendant, of their client. That means that they're going to be doing an investigation into multiple generations. It means they're going to be obtaining records that you wouldn't need in other cases. It means you're going to be retaining expert witnesses. You're going to be retaining somebody to counter every expert that the state has at the guilt stage of trial. If it's a forensic expert, if it's a hair expert, a DNA expert, whatever it is, an eyewitness expert. It means that you are going to be making an issue, I'm sorry, it means you're going to be trying to persuade the jury that this is a person who doesn't deserve to die, that this is a human being, this is not a monster. You have to humanize the person. And there are going to be mental health issues. And it may seem simplistic, but there are always going to be mental health issues because a murder is either in character or it's out of character. If it's in character, what is it about the defendant's background, the defendant's record, the defendant's history of mental illness or other history that makes it so that this terrible act was something that you could have anticipated it. If it's out of character, what is it about the circumstances of the offense, the circumstances surrounding the murder that caused the person to act out of character? Either way, you're going to need a mental health expert. And the studies have shown that almost everybody who is on death row has had extensive experience of childhood trauma. And we know that childhood trauma affects brain development. Childhood trauma affects mental health. Childhood trauma affects cognition. It affects your ability to understand the intentions of others, a whole range of things. And so you need to investigate the entire background of the person to understand that trauma, to understand the psychological impact of that trauma, to understand the neuropsychological impact of that trauma. And not surprisingly, people with this long life history of chronic exposure to trauma also tend to have brain impairments. So you need to have a neuropsychologist to test for brain damage and to explain what's going on. You will have, in many of these cases, a majority of the cases, mental illness of some sort or another. And so you will need a psychiatrist who can explain that. Because of intellectual disability, you're going to need to have a psychologist to assess the person's intellectual abilities. All of these things cost a lot of money. And it's not surprising then that it costs more to charge a case capitally and resolve it in advance with a plea bargain than it does not to charge it capitally and have it go all the way through trial and appeal. So death penalty costs more. Then there's the appeals. And the appeals take a long time. They take a long time because the courts are overburdened. They take a long time because capital appeals are much more complicated than the appeals in any other case. And they're more complicated in part because states don't provide adequate resources for defense counsel. And so there's much more in the way of ineffective representation that has to be investigated, and all of the things I just mentioned have to be reinvestigated. It's more difficult because when there's more at stake, prosecutors are more likely to take shortcuts or to cheat or to engage in misconduct. And all the studies show that the more horrible a crime is objectively, the worse the evidence is that prosecutors will use. There's a hole in my case, so how am I going to fill it? And in many cases, it gets filled with junk science. In other cases, it gets filled with snitch testimony. And we see the use of confidential informants or prison informants in 3 times as many death penalty exonerations as in other exonerations, because the prosecution wants to get this person. We've got a hole in the case, and so they go to a prison informant. There are all sorts of incentives to do the cases badly, and prosecutors have political gain. So if you have a prosecutor who is in the business to advance his or her career, you are much more likely in a high-profile case to have misconduct. And that doesn't mean that all prosecutors are bad. It doesn't even mean that most prosecutors are bad. But it means that prosecutors who gravitate towards the most sensational cases in order to advance their career have incentives to cheat. And one of the studies that we did when I was executive director of the Death Penalty Information Center was looking at cases that had been overturned to see how often prosecutorial misconduct was involved. It turns out that there are more than 650 cases and counting in which courts have overturned death sentences or convictions because of prosecutorial misconduct. And they only overturn these cases about a quarter of the times in which misconduct is present. If that's the case, then we're looking at misconduct in more than a quarter and maybe a third of all the capital cases. And that's something that creates all sorts of other costs. That's the cost of loss of faith in the judicial system. That's the cost of allowing people who are going to lie and cheat as prosecutors to climb up the career ladder. That's the cost of a justice system that gets known as being unjust.
I mean, so I had some of the things that you mentioned. I had it down here. Looking at one second here, let me find it. Looking at stuff in my phone.
Well, actually, can I on and when we're talking about death penalty appeals, because the penalty phase is a separate trial, it's a separate high-stakes trial, there's a lot at stake there. And in a non-capital case, you just have the guilt stage issues. Those very rarely get overturned on appeal. In death penalty cases, the penalty phase result, the death sentence, gets overturned much more frequently than in a non-capital case. So you see many more capital cases being reversed than non-capital cases. Now, it takes a long time. A lot of that is because the courts just move slowly. A lot of that is because there is so much at stake and you need to have a complete reinvestigation of a death penalty case. And folks say, well, let's just get it over with. Let's just carry out executions. The person was convicted. The evidence was overwhelming. Let's just carry it out. We're now 50 years into the U.S. death penalty since the United States Supreme Court struck down old death penalty laws. And there have been 200 cases in which people who were wrongfully convicted have been exonerated. 200. There have been about 1,600 executions. So we're looking at one person being exonerated for every 8 people who are being executed. That is an appalling rate of error. Now, we've already said that the most likely outcome of a death penalty case is that it's overturned. And if we think of this in terms of public transportation, let's say the death penalty is a train, and the station that you want to get to is that the penalty is going to be carried out. The most likely outcome once you hop on that train is that you go through this 20-year appeals process or more, and you end up where you started with no death sentence, and you've got to do another penalty phase, or the trial has got to be redone. And then you don't end up at that station afterwards. And when you do get to that station, let's do a slightly different analogy. When you get to that station, when you have the final outcomes, for every 8 times your plane lands where it's supposed to land, 1 crashes. If planes crashed with that frequency, we would be overhauling the entire aviation system. And why, with the death penalty, when we know it's a matter of life and death, are we not doing it? And that doesn't even get to the point that among those 8 people who were executed, how many of them should have been sentenced to death in the first place? A new study shows that, I'm sorry. Yeah. When we talk about one plane crashing for every 8 times the plane lands where it's supposed to, that doesn't even get into the questions about whether those 8 cases should have been executions, should have been death sentences at all. And a new study shows that about 14%, 1 in 7, of all of the executions were in cases in which the defendant had legal issues that established a constitutional violation that should have overturned the case. These were people whose death sentences were unconstitutional, and yet the courts declined to enforce the Constitution. Why? Because of procedural barriers, because of the way the system is set up. I mean, there were dozens of people who were executed in Florida before the United States Supreme Court said that courts had to consider all of the reasons to spare a defendant's life, all the mitigating circumstances that were presented by the defense. There were more than 40 cases of people being executed in Texas. I'm sorry. Let me do this a different way. So 1 in 7 of the cases in which people have been executed were actually cases in which the death sentence we know was unconstitutionally imposed. There was clearly established law pronounced by the United States Supreme Court saying that certain things were constitutional violations, and those things were present in these defendants' cases. And yet the courts refused to intervene to stop the executions. Maybe the person was guilty, maybe the person wasn't guilty, but the one thing we do know is that their death sentence should not have been imposed, and yet that they've been executed. This is especially prominent in states like Florida, in which about 1 in 3 of the people who were being executed had clearly established law saying that their death sentence was unconstitutional. It's the case in 1 in 5 cases of executions in Texas. That means about 100 people in Texas have been executed in violation of the Constitution. That's not the way a system of law should operate. If we're going to have a death penalty, it's important that we get it right. And when we're talking about getting it right, that means you don't break the law or refuse to enforce the law in order to carry out the law. But that's been a basic principle of these death penalty appeals. The federal courts will not intervene in a wide range of circumstances based on technicalities that should not be a basis to allow an execution to happen.
I guess for someone that's that's not in law and you're just an average person, that just seems unfathomable to me. I mean, so you have this system that is set up against you because you have certain people in place that could do something, could follow the law, and they don't. So what are the reasons? Is it politics? Is it race? Is it what is it? I mean, why won't they do what's right?
The death penalty has never been about justice. The death penalty has always been about social control. And when you look at it that way, once a death sentence is imposed, the ball starts rolling down the hill. And it's rolling towards this, I'm sorry. The death penalty has never been about justice. The death penalty has always been about social control. And the people who get sentenced to death are, when you look at the system as a whole, the most vulnerable of the most vulnerable. They're the people who were provided the worst representation. They're people who were intellectually impaired. They were people who were mentally ill. They were people who were represented by terrible lawyers. They were people who were represented by decent lawyers who were denied the resources necessary to handle the case right. And because these cases are so inflammatory, because these cases are so emotional, because there is so much political gain for prosecutors who are getting capital convictions, getting death sentences, you have a whole range of incentives that make it so that once a death sentence is imposed, that ball starts rolling down the hill. And even though more cases are overturned than reach execution, the ones that reach execution don't get there because the appellate system worked. They don't get there because we had the best court system in the world and the person had all the issues presented and heard. We get there largely on technicalities. If you are provided a substandard lawyer, and that lawyer doesn't raise claims of error at the right time at trial, those claims are waived on appeal. So if you have an appeals lawyer who recognizes that there's a problem, on direct appeal, most places you're not allowed to raise that issue at all. When you do get to raise it in a stage called post-conviction, different standards apply. So if your lawyer didn't raise an objection at trial, and had they raised the objection, your death sentence or conviction would have been overturned because the error was harmful, then on direct appeal, the state's highest court is going to look at that, they're going to overturn that, and that's that. If the issue is waived, it goes to the post-conviction stage, and you have to raise it as a claim that your trial lawyer was ineffective. And to prove that, you then have a different standard of prejudice. You have to show, one, that your lawyer performed unreasonably poorly, and that because of that error, there was a reasonable probability that the outcome would be different. That's a hugely different standard than the state having to prove that the error wasn't harmless. So the law stacks against you. It's also the fact that you don't have a right to a lawyer in the post-conviction stage. Now, most states give you a lawyer. Alabama doesn't, but most of the states do. But the fact that you don't have a right to a lawyer also means that it is harder for that lawyer that you get at that later stage to get the investigators who are necessary to investigate the problems in the case, to get the experts who are necessary, to get the resources that are necessary. I'll give you one example. Pennsylvania, there have been 150 cases that have been overturned in the post-conviction process. Why? Is that because Pennsylvania provides a right to counsel and provides counsel with the resources that are necessary? No. It's because there were nonprofit public defenders who had independent resources to handle those cases. There wasn't a Let me give you an example, Pennsylvania. There were 150 cases in Pennsylvania that have been overturned in the post-conviction process. And by the way, 100 of those have been because of ineffective representation of counsel. Were these cases being reversed because the state provided adequate resources? No. There was not one single post-conviction case that was overturned in Pennsylvania in which the defendant was represented by a court-appointed counsel who had to rely on court-provided resources. All of the cases in which you had to conduct an investigation, you had to get experts, all of those cases that got reversed because a law firm handled the case pro bono using its own resources, or the Pennsylvania Capital Case Resource Center was involved in the case, or the federal capital habeas units were involved in the case. There wasn't a single case in which a court-appointed lawyer relying solely on court resources overturned a case that required an investigation.
Right, ready?
Good to go? So let's talk about a little bit about race a little bit and how that plays a factor into this. Not that everything is about race, but sometimes it is. And the disparity that we find is that more black and brown folks, they are, sentenced and executed, not more, but
Disproportionately.
or disproportionately. What are some of your thoughts on that? What does the data show?
Well, I think there's history and there's data, and they both point in the same direction. The death penalty is an extension of slavery, lynching, and Jim Crow segregation. We can tell that because that's where most death sentences get imposed. We can tell that because about 80%, more than that, of the executions in the United States take place in the states that made up the former Confederacy. We can tell that because there's a direct relationship between locations in which lynchings occurred and locations in which the death penalty is used. And we can tell that when we look at the sentences and executions themselves. Race plays a role in a couple of different ways, and it plays a role everywhere in the death penalty system. It's not that the death penalty has a problem with race, it's that race is a major factor throughout the criminal legal system as a whole. But when we look at capital cases, what we see is that from the outset, there is favoritism. It is a race of victim favoritism. Prosecutors select cases for the death penalty, and you don't have to be a bigot in order to do this. Prosecutors select cases for the death penalty based upon the cases that they think are the worst. And well over 95% of the prosecutors who are making these decisions are white. And they feel that something is worse when a victim who is more like them is the person who is killed. Now, we can take this back to policing. Where are crimes solved and where are crimes not solved? Disproportionately, inner city crimes are not solved. And so when you're looking at the murders that occur, at the policing stage, you're much more likely to have a crime involving a favored victim solved first. So that means a child murder. That means a socially prominent victim. That means someone who is from a neighborhood that is better resourced. And as a result of that, from the very beginning, at the policing stage, you have more cases involving white victims getting solved, percentage-wise, than you have cases involving black victims and brown victims getting solved. Once the case is solved, I mean, I say it in quote marks because, as we know, 200 people who've been sentenced to death didn't commit the crime. And it's more than that, but those are the numbers that have been exonerated. Once you get the case into the legal process, the prosecutor has to decide which of these are the worst of the worst cases that are going to go forward capitally. And at that stage, there's some more narrowing. And the narrowing that takes place, again, has a white and white female race and sex of victim bias. So you are more likely to have a capital case at that stage charged if you have a white victim. When we move on to trial, we find that you are more likely to have a conviction and a death sentence imposed if the victim is white. And when we go through the appellate process, although appeals are supposed to be completely race neutral, it gets even more racially disproportionate. By the time we reach the tail end of the system, although half of the victims of murders in the United States are white, 3/4 of the victims in cases that result in executions are white. So there is a white victim preference. Now, how does that amount to discrimination against people of color? Well, here's what happens. When you look at murders, and we know what the race of the victim is, that's where we see the most obvious discrimination. We know that almost all murders are committed by people of the same race against people of the same race. And so you would expect an overwhelming percentage of murders of white victims to be white defendants. That's not what we see. We see that black defendants are disproportionately sentenced to death in interracial murders. And white defendants are almost never sentenced to death in interracial murders. There's a famous study that was done by a sociologist and lawyer by the name of David Baldus out of the University of Iowa. And it produced an S-curve. And the graph, you run across the graph, and it starts at the lowest level of severity, running to the highest level of severity. And it's broken down by the race of the defendant and the race of the victim. And you see these 4 S's. They move across, and you come relatively slowly, and then it zips up as the cases become more severe, and then it levels out. What it shows is that at all levels of severity, there is a distinction between who gets sentenced to death the most. And if you have a white victim, whether you are white or black, you are more likely to be sentenced to death than if you have a black victim. If you are a black defendant, you are more likely to be sentenced to death whether or not you have a white victim or a black victim. So what gets you death the most is a black defendant and a white victim. What gets you death the next is a white victim and a white defendant. And then next, a black defendant and a black victim. And the least likely is, crap. Yeah. So what gets you death the most is a black defendant and a white victim. What gets you death the least is a white defendant and a black victim. And in between, when it's same race, if you have a white victim, you're more likely to get death. So there's 2 levels of discrimination. A case gets into the death penalty system. So there are 2 levels of discrimination. A case gets into the death penalty system much more frequently if the victim is white. And then when you look at the race of victim boxes, you find whatever that is, whatever race it is, you are more likely to be sentenced to death, and you are more likely to be executed if you're a defendant of color who has committed the murder.
So let's...
I'm sorry. Race has an even more pernicious effect among the most vulnerable of defendants. So people who didn't do it, people who were young, people who are intellectually disabled. And what we see is that a majority of the innocent people who are sent to death row and later exonerated are black. What we see is that about 80% of the individuals with intellectual disability who have been sentenced to death are people of color. 2/3 of them are black. And when we look at the young defendants, the people who are age 16 and 18 before that was declared unconstitutional, the people now who are between the ages of 18 and 21, the late adolescents who are being sentenced to death, they are overwhelmingly defendants of color.
I want to talk about, you talked a lot about the brain science and how, young folks and rehabilitation, and we focus too much on punishment. I want to talk about that a little bit later here, because I think that's very important. So let's talk about the counties. When you're a DPIC, I think you headed up a study, or you, as far as the counties that are responsible for the majority of the death penalty cases and executions. Can you speak a little bit about that?
Okay, a little bit of background. People think of the death penalty as being a national policy. And in fact, people think of the death penalty as being a national policy. And in fact, federal death row is a tiny portion of death row as a whole. The death penalty is a creature of individual states. As many as 40 states had the death penalty when it was declared unconstitutional in 1972. And then states began to bring it back afterwards, and we got up to 38 states with the death penalty. We're now down to 27. Well, that's fine if you're thinking about what law governs these death penalty cases. State law governs those cases, of course, subject to the U.S. Constitution. But states are not where the action is in capital cases. The death penalty is actually a county policy. And most counties in the United States have never imposed the death penalty. 80% of the counties in the United States have not imposed the death penalty. 82% of the counties in the United States have nobody on death row. 85% of the counties in the United States have never carried out an execution in the past half century. There was a study done by the Death Penalty Information Center in 2012 that found that 2% of the counties in the United States accounted for half of everybody who was on death row. When I was executive director at DPIC, we did a death penalty census, the broadest study of who was sentenced to death in the United States. And we tracked more than 9,700 death sentences. And we broke them down by county. And what we found is that at the start of 2021, it was no longer 2% of the counties creating half of death row. 1.2% of the counties were responsible for half of everybody on death row. That's fewer than 50 counties in the entire United States that account for half of everybody who is in jeopardy of being executed. And one of the things that is really interesting about it is that of these outlier counties who disproportionately produce death sentences, in those counties there's been a significant national trend, and it's the trend away from capital punishment. We've seen this in public opinion polls. Support for the death penalty has dropped from 80% in the 1990s to 53% today, the lowest that it's been in 50 years. And a majority of Americans now believe the death penalty is unfairly administered. Well, at the same time that support for the death penalty plummeted, use of the death penalty was dropping. And when we look at what used to happen, we counted the death sentences imposed by counties in every year, and we ranked them. And the 34 most death sentences per year came from a grand total of 4 counties. There's 1 or 2 exceptions in there, but more than 30 of the 34 highest death sentencing years came from just 4 counties. And those counties were Los Angeles, which still has the largest death row in the United States; Harris County, which is Houston, which has executed more people than any other county in the United States, and has executed more people than any state except for Texas; Philadelphia, which in 2001 had more African Americans on death row than any other county in the United States; and Chicago, Cook County. Those 4 counties accounted for the worst death sentencing years, the 30 worst death sentencing years in the United States. Well, Illinois doesn't have the death penalty anymore. Philadelphia and Los Angeles have elected reform prosecutors who do not believe in capital punishment, and they are not imposing the death penalty anymore. And Harris County, which is Houston, still is seeking the death penalty, but the district attorney there says that the way the state used to pursue the death penalty is unacceptable. And so there are 1 or 2 death sentences a year instead of 10 or 12. We have seen this change in the United States in attitudes towards punishment, a belief that punishment isn't the answer. Punishment doesn't make us safer. And the death penalty as a policy does not make the public safer. So if you have a reform prosecutor who is interested in using the criminal legal system as an instrument of social justice, and is interested in actually finding policies that will make the public safer, you see an emphasis moving away from punishment to diverting things, to prevention. And that's what's happening. The big death penalty producers are still disproportionately producing death sentences, but the number of death sentences has plummeted. And so we've gone from more than 300 death sentences a year in the mid-1990s to 9 straight years of fewer than 50, and 5 straight years of fewer than, 9 straight years of fewer than 50.
Yeah, it's amazing. Let's talk a little bit about this whole idea of ethnic adjustments. And I think you and I, we spoke
Yes.
on the phone. So give me your thoughts on that, and how have things changed since, was it Texas? Was it Texas or Florida?
Well, Dr. Dankowski is Texas.
Yeah, Texas. Okay, Texas.
In some respects, intellectual disability is where the desire to carry out executions and racially discriminatory policies come together. One of the things that states that want to carry out executions have done is impose all sorts of procedural barriers to presenting claims of intellectual disability. Another is they've presented expert witnesses who provide scientifically false testimony and racially offensive testimony to show that individuals, or to try to prove that individuals who would be deemed intellectually disabled if they were white are not intellectually disabled. It's a concept called ethnic adjustments. And it raises its head in 2 respects in the intellectual disability cases. First, when you test somebody for IQ, the tests all have what are called norms. A group of people who are supposed to be representative take the test, and then you get a midline score, a norm. And then you can scale it to see what is 2 standard deviations below the norm, that's intellectually disabled, or that's considered evidence of that, who is brilliant, and so forth. Well, it's normed against the US society as a whole. And if you're going to decide whether somebody is intellectually disabled, one of the things you look at is how far below the national norm that person scores. What experts for the prosecutors have tried to say in a number of cases is we shouldn't be norming it against the U.S. population as a whole. We should be norming it against other African Americans. And that raises all sorts of issues, because what we know as a scientific fact is that people who are poor score poorly by comparison on tests of intellectual functioning. There are a lot of reasons for that. There's nutrition, there's the environment, there's lack of educational opportunities, and so forth. But in general, the statement is a true statement that if you're poorer, you're going to score less well. So who is disproportionately poor in the United States? Communities of color. And when you make this ethnic adjustment, and so you test how somebody scores against a group that is already disadvantaged on the test, then you're going to end up with a person who, if they were white, would be considered to be intellectually disabled. But if they are black, will not be. And interestingly, the same doctors that will say you need to make these ethnic adjustments with black and Latinx defendants to determine their IQ, when they are testing a white defendant, they're not using the ethnic adjustments. Because if they use the ethnic adjustment in that case, the defendant would be more likely to be found to be intellectually disabled. So it's a win at all costs distortion of science in order to say that someone's not intellectually disabled. A second area where it comes in is in assessing adaptive deficits. To be intellectually disabled, you have to have significant impairments in daily functioning. And so these same doctors who are trying to make ethnic adjustments about intellectual capacity are saying, well, no, we have to look to see, is this person functioning, is this a significant impairment based on the way people in that community function? And all you have to do is say it that way to understand how it seethes with race. And not surprisingly, the people who are making these ethnic adjustments aren't making ethnic adjustments to say that white people should be found to be intellectually disabled. They're using them to say that black and brown people should not. Essentially what it comes down to is this. You have doctors saying that somebody who, by normal, accepted community standards, pure medical science, pure mental health science, people who would be found to be intellectually disabled are not. And if you ask them the question, this one question, if this defendant were white, would you say he is intellectually disabled? The answer would be yes. They're using standards that make somebody eligible for the death penalty who shouldn't be eligible for the death penalty, and that eligibility is based solely on race.
Could you repeat that from if this person was white, your stomach was rumbling.
Oh.
We really heard it. So, sure it wasn't me.
Okay. And so if you ask the doctor this one question, if this defendant were white, would you say he was intellectually disabled? They would have to say yes. And so you have defendants, black and brown, who are being sentenced to death, who are being executed solely because of their race.
Thank you.
So let's talk a little bit about this whole idea that I think we touched on a little bit earlier, punishment versus rehabilitation, some alternatives, some things that I heard you say about, us focusing so much on punishment. We don't really focus on rehabilitating the person, the fact that, most of these people that commit these heinous crimes are young, their brains haven't developed. Can you speak a little bit about that?
my stomach's about to rumble again.
There's something else I want to add in there, because I think you also talked about, providing, I think you termed it meaningful rehabilitative services, or meaningful services for the victims' families too.
Mhm.
Because a lot of times in this discussion about the death penalty, we don't really spend a lot of time talking about the victims' families,
Yeah.
people that lost their loved one.
Yeah.
So if you can kind of talk about all of that, it'd be great.
The United States is the most punitive democracy in the world. We are the only Western democracy that has the death penalty, and we are the rare democracy that, as a humane alternative to death, sentences people to death in prison, life without possibility of parole. Now, those policies don't make sense from a public safety perspective. Those policies don't make sense as a matter of deterrence. We looked at 30 years of homicide data, because if the death penalty actually does reduce murders, then that's a reason to have it. And we looked at 30 years of data on the killings of police officers. We looked at 30 years of data on the killings of police officers, because if the death penalty makes police officers safer, that's a reason to have it. So what did we see? What we found is that, on average, every year, murders are higher in states that have the death penalty than in states that don't. Police officers are more at risk in states that have the death penalty than in states that don't. Well, maybe that's a product of, gee, Texas is a big state and it's skewing the numbers, and Rhode Island doesn't have the death penalty and there are almost no numbers at all. So maybe we shouldn't average the states. Let's look at the states as a whole. So we did. And when we did that, we found that clustered among the states that were the safest were basically two groups: states that didn't have the death penalty, and states that had the death penalty but didn't use it. And clustered among the states that were the least safe were the death penalty states and the ones that used the death penalty. When we looked at police officers, the killings of police officers, we found something similar, except clustered among the safest states for police officers were the states that had most recently abolished the death penalty. That makes no sense if the death penalty is a deterrent. And I think it's ridiculous to say that abolishing the death penalty makes police safer. I think what it tells us is whether you have the death penalty or not has nothing to do. Whether you have the death penalty or not has nothing to do with police killings or killings in general. The reason that states that have abolished the death penalty appear to be safest for police is because it's actually the other way around. When police are not at as bad risk, when police are safer, when there are fewer killings of police officers, the killings of police officers becomes less of a political issue. And when it's less of a political issue, it has less of an impact on legislative debates. And when it has less of an impact on legislative debates, legislatures take a look at whether the death penalty actually does what it's supposed to do. Does it make people safer? No. Is it cost effective? Well, two problems. One, it costs more, and two, it's less effective. So when it comes down to a question of policy, when you have fewer murders of police officers, you have a state that's politically more likely to repeal, and that's what we found. And now I forgot what I was answering before that.
No, we're talking about punishment versus rehabilitation.
Okay. So following up on that study that I did when I was a DPIC, the Death Penalty Policy Project just looked at numbers from every town for gun safety. And every town does an analysis. They're a nonprofit group that's interested in essentially combating gun violence. So they've ranked states based on how strong their gun safety laws are. And their database, and their website has a list of states in order, and it also lists the rates at which people are killed with guns. I wanted to find out, is there a relationship between gun safety and the death penalty? So it turns out that among the states that have the strongest gun safety laws, well, you have less gun violence. That seems to be a policy that would work. Who are the states that have the strongest gun safety laws? They're overwhelmingly states that have abolished the death penalty or don't use it. Who are the states that have the weakest gun safety laws? Who are the states that have the weakest gun safety laws? They're death penalty states. And when I looked at the numbers for the actual rates at which people were killed, the same patterns. The same patterns. Death penalty states had higher rates of gun violence than non-death penalty states. Well, I mean, maybe there's something anomalous about that. Maybe if you execute people more, it'll have an effect. Maybe it's the use of the death penalty that should make the difference. So I looked at that. Not the case. Among the 19 safest, looking at the 15 states that over the last 50 years have carried out the most executions, none of them ranks in the top 19 for safety, for gun safety. And 11 of them rank at the bottom. So what seems to be the case, and this fits in the whole thing about the death penalty being an exercise of social control, not a tool of public safety, is that the states that carry out the death penalty seem to be more interested in appearing to be tough on crime and less interested in doing things that actually make the public safer.
Rolls back into that politics thing, you know?
And I can give you all the graphs for that.
Yeah. I'll reach out to you about that. That's going to be really, really interesting.
Yeah, I just published, I published them on my Substack last week.
Okay, cool. Let's talk about rehabilitation and, how that's important in this whole, as an alternative. We're talking about alternatives to the death penalty, and I think you've written or spoke about how it's important to have programs that provide meaningful services and things of that nature. So let's talk about that. Just touch on that a little bit for both the condemned and or the victim's family.
One of the things we keep seeing over and over is that the death penalty is bad for people. And it doesn't really matter who you are in the system. The death penalty is obviously bad for capital defendants. The death penalty is bad for capital jurors who get traumatized by what they see. The death penalty is bad for defense lawyers and prosecutors who end up with secondary trauma based on everything that they see. And the death penalty is extremely bad for the members of the victim's family. An important study was done. It was published in the Marquette Law Review that looked at the health, physical, emotional, mental health of victims' families in states that had the death penalty and states that didn't. Well, that looked at the health, physical, emotional, mental health of family members of murder victims in Texas, which has the death penalty, and Minnesota, which doesn't. What the study found was that at all stages of the process, the family members were better off in Minnesota than they were in Texas. And essentially, it's because the death penalty is a false promise for the family members of the homicide victims, when the most likely outcome is that it's not going to be carried out. Whatever promise was made up front, that justice is death for the offender, that doesn't happen. And even when it does, only about 2% of victim family members report that they obtained, quote, closure. What happens is that the long appellate process rips open the scars every time. The long appellate process re-victimizes family members. The appeals process is not about their loved one. It's about the defendant and whether the death sentence is appropriate in that case. The defendant is the central focus. The victim and the victim's family is an afterthought. But every time there is a new hearing scheduled, every time the hearing takes place, every time there's a ruling, the wounds get reopened. And when the ruling is that the defendant gets a new trial or the death sentence gets overturned, that is a significant bad event for the victim's family. When the ruling is in the favor of the state, that moves the case to the next level of appeal. And that appeal continues to reopen the wounds for the victim's family. If it eventually results in an execution, the family has held on to its anger for an extended period of time. We're talking about 15, 20, sometimes 30 years. And so the death penalty, rather than promoting healing, worsens the wounds and delays the healing process. When a defendant doesn't get death and gets sentenced to life without parole or a term of years, the case is often just done with. There are often no appeals at all, and when they are, the appeals are much shorter. And that lets the family member heal sooner. So the death penalty is not good for victims' families members. Now, now let's look at the other side. Well, now what should society be doing? Family members who have lost a loved one have an unspeakable loss. And we have an obligation to provide them services to help them heal. That means something that's meaningful. That means not just financial compensation, because you can't compensate for the loss of the life. But it should mean some kind of social services. You should have compensation to make sure that the family doesn't financially suffer as a result of the loss of the loved one. But you need to take care of their emotional needs. And just far too frequently, the concentration on let's get the death penalty diverts focus and diverts resources from programs that can legitimately help family members of murder victims. On the other side, there are problems as well. And you might say, well, wait a second. If a person doesn't get the death penalty. They get life without parole. They're never coming out. Well, let's look at the reality. 200 people innocent and exonerated. Most of the rest, a majority of the rest, conviction or death sentence overturned. They will then be moved from death row into the prison community. Our punitive process, our punitive emphasis, has put people who are on death row in solitary confinement, which has devastating mental and emotional impacts. If you're going to be in solitary confinement 10, 15, 20, sometimes 25 years, and then you're going to be freed because you were innocent, or then you're going to be returned to general population, you have just created a dangerous situation. If we did the humane thing and treated prisoners like people, then you find that making services available, making educational opportunities available, making training available, that helps. That makes prisons safer, that reduces the degree and the extent of mental illness that people who have been sentenced to death suffer. That makes it easier to adjust to society when you come out. And it's just a humane thing to do. The policy of let's punish as much as we possibly can doesn't work. It doesn't make society safer. It doesn't make society a better place to live. It doesn't make us better people. It doesn't do what it's supposed to do. What makes more sense is litigating in a way that's smart on crime, that looks for alternatives to incarceration, that looks for ways of preventing crimes from taking place and mitigating damage before it gets too great. And that's something that we've been bad at from the 80s, the 90s, and even into this century. But that's something that the reform prosecution movement has been much better at. We're at a crossroads right now where we're going to see if this movement continues to advance or if, emboldened by the actions of the United States Supreme Court, states become more punitive again. And we don't know what direction it's going to go. But we do know that it's created a new battleground. And that battleground is the legislatures. And that battleground is local elections. Local judges who impose sentences, local prosecutors who decide what sentences to pursue. And it's at that level that we are going to see whether this becomes a more humane society or whether we're going to be an outlier among democracies and the harshest punishers of any of the, quote, civilized countries.
Let's stop for a second.
Just give me one more square too.
Okay. There's an image that I think captures what the death penalty is about, where it came from, and what underlies much of the support where it still exists. The support that underlies the support irrespective of the evidence that death penalty just doesn't work. Because the image makes us understand that the facts don't matter. There's two pictures. One of them is the execution of Rainey Bethea, the last public execution in the United States on the courthouse lawn in Kentucky. The other is a lynching in 1893 in Paris, Texas. And there are photographs of both of these. We put them side by side in the Death Penalty Information Center's report, Enduring Injustice. Both pictures show large crowds, white audiences filling up the courthouse lawn, overflow crowds. Both pictures show an African-American man being led to the gallows, up on the gallows, getting ready to be hung. One of the pictures has the word justice painted on the gallows, and that's the lynching. The death penalty isn't about justice. It's about social control. Rainey Bethea was sentenced to death and executed for rape. Now, there are questions about whether he did it at all, but the reason that he was charged with rape and executed for rape instead of murder was because Kentucky law at that time provided that if you were sentenced to death and executed for murder, the execution would take place inside the prison walls. In order to make a public display with the greatest public impact, they didn't execute him for murder. The whole point was to make the execution as dramatic and horrifying as possible. And it was a way of expressing social control. A lot of that emotion is still in play in the death penalty. You see people who, when they talk about methods of execution, are almost gleeful that some methods may appear to be harsh. And they want to compare that suffering to the suffering that the victim may have experienced or did experience during the murder. That's not what law is about. That's not what humanity is about. That's what using the legal system as an instrument of vengeance and control is about. That's not constitutional. That's not moral. That's not the American way. And that is an ongoing issue with capital punishment today.
Reminds me of, you're familiar with Michael Prof, New York Law School, I think. We interviewed him a few years ago, and he said, same thing. He said the death penalty is about vengeance.
Well, everything I know I got from somebody else.
No, I'm just saying,
No,
I
yeah,
don't know if
no.
you knew him or
No,
not.
I don't know him.
Because stupid me, I think that all attorneys know each other. So, like if you're in the same profession, and he's all about social justice as well. So I just assumed that you guys knew each other. Let's talk about anything I may have missed in this discussion. The purpose of this film is to raise awareness and get people to think. Okay, why are we still doing this?
Mm-hmm.
So, in that, what are some of the things that I may have missed? Maybe there are some questions I should have asked that I didn't. Different points that you may want to make or put an exclamation point at the end of something. So I'll just open it up for you.
Despite everything, despite the United States Supreme Court seemingly taking itself out of regulating death penalty policy, support for capital punishment continues to decline. We've gone from more than 300 death sentences per year, a decline of about 80%. We've gone from 98 executions in 1999 to 9 straight years of under 30. We've gone from 80% support in the polls to 53%, with now close to 2/3 of Americans saying that they prefer alternative sentences to the death penalty. And we're seeing support for death penalty dropping away among people who support the death penalty. They just don't support this death penalty. Stephen Urquhart was a state senator in Utah. And when Utah could not carry out executions because they couldn't obtain lethal injection drugs, Senator Urquhart voted in support of a bill to bring back the firing squad. He later said he hadn't really thought about it. We had the death penalty and we should carry it out. But then he said, it made me think, should we have the death penalty? And as a conservative with general concern about the ability of government to get things right, he asked his other friends in the legislature, can you name a policy that we get right most of the time? And they hemmed and hawed, and maybe they came up with one or two. Then he said, can you think of a policy we get right all the time? And nobody could. At that moment, Senator Urquhart became a death penalty opponent. We get it wrong a lot. And if we don't trust the government to fill potholes, to regulate shoelaces, to do all sorts of things properly all the time, how can we justify getting it wrong when it's a matter of life and death? For conservatives, and I think for liberals as well, there are core principles. They just get looked at through different lenses. One is a distrust of government. The other is a distrust of civil rights violations. One is fiscal conservatism. The other is we shouldn't spend money killing people. One is this policy is just not moral. The other is this policy just can't work. But no matter how you look at it, with the death penalty, there are so many different things that are wrong with it, that whether you are liberal, whether you are conservative, whether you just don't want to kill innocent people and don't want to not know whether someone you've killed was innocent, there's only one answer, and that is to prevent those errors from happening. You got to get rid of it. So for abolitionists, we've seen a major change. Growing support among conservatives to get rid of the death penalty. Bridging the gap between people who politically don't really talk to each other very much. The irony that a policy that's this divisive might actually be able to bring people together and to recognize their common humanity and their common support for decency. Are you pro-life? Do you believe in the sanctity of life? Well, then how can you be killing people, especially when we know that the death penalty is not very good at differentiating between who actually did it and who didn't? All of these things keep coming up over and over and over. And there was a thought among death penalty abolitionists that it'll go to the Supreme Court and they'll make the death penalty go away. That's no longer the case. This Supreme Court won't do that. Now the abolitionists have to focus on state legislatures and local elections. And now state legislators who maybe secretly thought the US Supreme Court would take care of it so they wouldn't have to take any kind of political risks. Now that moral judgment rests with them. That's hard for some of them to understand, but they should be heartened to hear that all the recent public opinion polls show that voters will not vote against a candidate of their own party based upon a disagreement about capital punishment. This is now something that voters understand is a question of conscience. And it's not the 1990s. You won't be booted out of office. You have the opportunity now, if you have the moral courage to do it, to vote for the death penalty. Yeah. You have the opportunity now, if you're a legislator, if the opportunity presents itself, to vote according to your conscience. And that, the abolition community thinks, is going to cause more and more states to do away with capital punishment. Is it going to disappear from all the states in the Deep South? I think that's highly unlikely. I think ultimately that's something that a future Supreme Court is going to have to address. But I do think, being optimistic, that in the long run, and this is now a cliche, the arc of justice, right? And Martin Luther King, it was his birthday, and I screwed up his quote. I think abolitionists are counting on, and I believe it's true, as Martin Luther King said, that there's a moral arc to this universe, and it bends towards justice.
Amazing, amazing. Awesome. Do you guys have any questions, anything? Sometimes I like to ask the crew if they have a question they want to ask, something.